Uh, my name is Bob Burnett, and I'm joined here this evening with my friend and colleague, Brendan O'Donnell. And I also wanted to say thank you to everyone for joining us on this rather nice Wednesday evening here in Western Pennsylvania. I'm not sure where you might be watching this video, but it's pretty nice here in Pittsburgh. This is our fourth installment. It's the Oil and Gas Legal Update Winter 2022. You know, when we were putting the PowerPoint together, it seemed like winter was never going to end. So that's why we called it Winter 2022. But perhaps spring has finally arisen, and we'll just go with the St. Patrick's Day version in honor of my colleague, Brendan O'Donnell. Tonight, we're going to talk about 6 cases. There have been some recent developments, especially in the lease expiration ownership side of the equation, that impact and discuss what is oil and gas ownership. And when you sign an oil and gas lease, what interest is created, and how does that interest terminated, and what happens when it does terminate. And then we'll discuss a number of royalty cases that, as usual, discuss the deduction of post-production costs and what it means to own and have a royalty interest under an oil and gas lease. So again, if you have questions, you can submit them, and Megan will route them to us, and we'll try to address them as soon as we can, and hopefully we can answer them. So let me get started, because we have an hour, and there's a lot of material to cover that is both relevant and fascinating. First case we're going to talk about is from Kentucky, and it was decided back in January. It's a recent case from the federal court in Kentucky, and it represents and illustrates the ongoing tension and perhaps confusion between contract law and property law, because an oil and gas lease is essentially both. It's a contract, but it's also a conveyance. And practitioners, as well as lessees and lessors, sometimes forget that at the core, an oil and gas lease is a conveyance of a property interest. And even though there's a contract, and those contractual terms create obligations, privileges, and covenants, at its core, it's a conveyance. The Bluegrass Materials case illustrates that distinction. At issue in Bluegrass was a 1985 lease, had a 1-year primary term. 2 shallow wells were ultimately drilled and went into production. Those wells produced from the mid-'80s until September of 2015, when both wells ceased production. And that cessation of production lasted for about 11 months. When production resumed in 2016, it was minimal. I think the record reflected there was 20 barrels were ultimately produced in that fourth quarter of 2016. So the landowner filed a lawsuit seeking judicial termination of the 1985 lease. And the theory was the lease had expired due to non-production. Those 11 months of non-production, there was no shut-in royalty, there was no request for suspension of production because of some mechanical failure. Those wells just ceased to produce, and the lessee had not provided a shut-in royalty or taken any other steps to mitigate the non-production. The driller defended on 2 grounds, and we're seeing this more and more here in Pennsylvania. The driller argued, hey, you never gave us prior notice of a breach, and you didn't give us an opportunity to cure. Therefore, your lawsuit in and of itself is premature, and the court should dismiss it outright. The second argument that the driller made was waiver, that you accepted royalties between 2010 and 2015, and then after production resumed in the fall of 2016, you accepted those royalties in 2016 and 2017. Therefore, you waived the right to bring a lease expiration claim. Next slide. You know, the district court ruled in favor of the driller and dismissed the complaint at the motion to dismiss stage. I believe that this case was wrongly decided and is deeply flawed. First and foremost, district court said that under Kentucky law, when you argue that a lease has expired, that the lessee has breached an express covenant in the lease, you have to give an notice and an opportunity to cure. Now, we don't have that same nuance here under Pennsylvania law, but we do have a lot of leases in Pennsylvania that contain a notice and cure provision. So even though the facts of bluegrass would be different, because the law in Kentucky is slightly different than here in Pennsylvania, the premise of the bluegrass decision remains the same. And in bluegrass, the court said, the failure to produce in paying quantities, that's a breach of an express lease obligation. They never point to where in the lease it was expressly stated. They just argued that, well, this must be an express lease obligation, and therefore under Kentucky law, you had to give notice and an opportunity to cure. And the court also accepted the driller's argument that even if we didn't rule in favor of the notice and cure provision, there was a waiver here because you accepted royalties after 2016. Next slide. Again, respectfully, the district court opinion is flawed. And it conflated and confused the nature of what an oil and gas lease really is. It is a conveyance. And what is being conveyed is something known as a fee simple determinable. That's the name of the property interest that is created when you sign an oil and gas lease. And a fee simple determinable conveys the exclusive right to remove hydrocarbons under your property. That's what is conveyed. But it's called a determinable estate because there are events that can occur that automatically terminate that property right. And in an oil and gas lease context, that determinable event is non-production. And in Pennsylvania and in other jurisdictions that adopt and recognize a fee simple determinable, when a determinable event occurs, the automatic termination rule is triggered, which means the fee simple interest automatically terminates. When this lease, the 1985 lease, ceased producing in August of 2015 and remained in a state of non-production through September of 2016, that is a determinable event that terminated the property interest. The lease automatically terminated. The district court's opinion did not even mention that or discuss that unique aspect of an oil and gas lease, and instead focused on this nuance of Kentucky law that if there was a breach of an express provision, you had to give notice and an opportunity to cure. The failure to produce is not a breach of an oil and gas lease. It is a determinable event that terminates the property interest. And the district court overlooked that important distinction. Second, you cannot revive an expired oil and gas lease. And the next case that we're going to talk about, which is actually a Pennsylvania case, touches upon that exact issue. That drillers seem to suggest that even if a lease expires, they can revive it by just resuming production. And that's simply not the law. Again, with a fee simple determinable, when that determinable event occurs, the property interest automatically expires and terminates. You can't revive it. You can sign a new oil and gas lease, or you could sign a lease ratification agreement whereby you consciously and knowingly ratify the expired lease, but you can't automatically revive an expired oil and gas lease by simply resuming production. Now, there can be particular clauses in an oil and gas lease that try to temper and modify this property law concept, and they might be applicable in your situation. But from a general principle of law, when a determinable event occurs, the fee simple interest terminates and the automatic termination rule kicks in. That is generally the law here in Pennsylvania. The third flaw in the district court opinion is this notion that you can cure a period of non-production. One of my favorite movies is Back to the Future. And it seems like drillers like to play that same game with periods of non-production, that they can go back in time and somehow produce. If there is a period of non-production, and in here, in the Bluegrass case, there was no production. It was undisputed between August of 2015 and September of 2016. There's no production. You can't go back in time and cure that. There's no time machine that allows you to go back and suddenly produce hydrocarbons from the lease. It happened. It was a determinable event, and it's not subject to cure. That's why the whole notion of applying these notice and cure clauses to non-production is really of no moment. It's apples and oranges. You can't go back and cure a period of non-production, just like you can't revive an expired oil and gas lease. So the takeaway from Bluegrass Materials is, number one, it's a Kentucky case, and hopefully Pennsylvania courts will not follow or adopt the flawed logic of that opinion. But to the extent there are notice and cure clauses in your oil and gas lease, drillers may try to cite Bluegrass as a persuasive opinion. And again, for the reasons we just articulated, the opinion is flawed and really should not be adopted in any sense by Pennsylvania courts. Now, the next case we're going to talk about, and my colleague Brendan is going to address the case. It is a Pennsylvania case that addresses the fee simple determinable under Pennsylvania law. It's a critical decision, and it was decided in December of 2021. Brendan, why don't you go over the Allison case for our audience?
Sure. So this is a Pennsylvania Superior Court decision, a fairly recent vintage, arising out of a lease in Greene County, Pennsylvania. As a caveat, this is a case that is still ongoing, and it is a case where Bob and I represent the landowners who are the plaintiffs in this matter. So our comments here are strictly focused on what occurred in the Pennsylvania Superior Court, the fairly narrow issue that the Pennsylvania Superior Court addressed, because a wide variety of details of this case are still ongoing. It's back in front of the Greene County Court of Common Pleas, but the Superior Court's view of a particular legal issue here is relevant. So in this particular case, this was a lease over 100 years old from 1913. There was a single old shallow well on the property. The landowners allege that it last produced around 1991. The production from that well is an issue in this case, but it's the landowner's allegation it last produced around 1991. In 2017, the landowners entered into a new oil and gas lease, or new oil and gas leases with Rice Energy. And then in a somewhat interesting situation, EQT claimed the interests in the property lease under the 1913 lease, and then it acquired Rice Drilling in 2017. And then oil and gas production from Marcellus wells began around that same time period, and EQT paid royalties under the 1913 lease. The question in the case was whether, and the question in the case still is, whether the 1913 lease expired due to non-production of oil and gas, which the landowners alleged occurred in 1991. The matter was subject to summary judgment motions, and an argument advanced by EQT was that even if production ceased in 1991, it didn't matter because Marcellus shale production began in 2016, which revived or breathed new life into the 1913 lease. The issue of whether, again, the issue of whether the old shallow well actually stopped producing remains at issue. And ultimately, that's not germane to this analysis because the Superior Court took the summary judgment question of, if it terminated because of non-production in 1991, could a subsequent event, like the beginning of Marcellus shale production, revive or breathe new life into that 1913 lease? It was the landowner's contention that because they believed that production ceased in 1991, any rights to the property that the driller had became what is known as a tenancy at will, that could be terminated by any party at any time. The trial court granted summary judgment for EQT, reasoning that the resumption of production from the Marcellus shale, or the beginning of production for the Marcellus shale, if one were to simply look at that event, caused the 1913 lease to be in effect. Essentially, the court believed that the 2016 production, regardless of the Act 152 notice that the landowners had transmitted to the gas company, the beginning of Marcellus shale production eliminated any issue about lease termination that may have arisen prior to that. The matter was appealed to the Pennsylvania Superior Court, and the Pennsylvania Superior Court examined the narrow issue of, if there is a cessation or a stoppage of production under an oil and gas lease, and the lessee, the driller, later begins new production, does that new production revive or reinvigorate the original lease? And the parties took positions at before the Superior Court, similar to had been presented before the trial court, with the landowners arguing that if a lease terminates, if a lease stops producing, it terminates under the automatic termination rule, the fee simple determinable goes away. And therefore, all that would be left is that tenancy at will, which is akin to a situation where someone holds over on property, that their rights may continue so long as both parties agree that they can be there. On the other hand, the gas company argued that in this particular situation, the beginning of Marcellus shale production eliminated all issues and cemented its rights on the property such that they could not be terminated by the landowner. The Pennsylvania Superior Court reversed the trial court's entry of summary judgment for the gas company, and they wrote, resumption of oil or natural gas production on the property during a tenancy at will has no bearing upon either party's right to terminate that form of tenancy. In our view, the Superior Court's recitation or identification of what a tenancy at will means was consistent with long settled Pennsylvania law and with long settled Pennsylvania oil and gas law, which identifies that if an oil and gas lease is defined by the period of production, then the cessation of the production will end the driller's rights. The driller may continue on the property. The driller may continue to produce oil and gas, so long as the landowner, oil and gas owner, allows them to be present. But it is not a lease. It is an at-will tenancy that can be terminated at any time and for any reason by either party. There's no need for mutual agreement. There's no need for a reason. You can say, it's a Wednesday. Your rights are over. That's the nature of a tenancy at will. And that's what the Superior Court's decision here was. And it's important because it fundamentally recognizes the fee simple determinable nature of an oil and gas lease, that is, whose term is defined by production. And it reinforces the nature that when an oil and gas lease's term is based on the production of oil and gas, there has to be production of oil and gas. And if the production of oil and gas does not occur, subsequent events, years later, will not have the ability to revive that old lease. So it has a benefit in terms of that statement of the law to make clear, because there are many leases in Pennsylvania, many old leases. And a fear was, if there is an 1882 oil and gas lease on a piece of property, that was never surrendered, could somebody come along and say, you know what, I'm going to sink a well here and I'm going to start producing because I'm going to claim that somehow I bought this interest from somebody else and that lease was never surrendered. And as soon as I start producing, that old lease comes back into play, and you, the oil and gas center, you're stuck with whatever that 1880 or 1885 lease was. And that's a significant public policy issue. It's a significant restriction on the use of real property. So it was good to see the Pennsylvania Superior Court resolve that issue. As noted, it's been remanded back to the trial court in Greene County for further proceedings and open questions of litigation of whether there actually was a termination of production in the old shallow well. That issue has not been resolved. And simply the issue on appeal that we're talking about was based on the summary judgment argument that if it had terminated, was the lease still in effect? And the Superior Court said no. And ultimately we'll find out from the Court of Common Pleas whether the lease continued because there was production or not, which is to be determined. And we may bring you that result at some point in a future presentation.
Thanks, Brendan. I just to summarize the two cases of Bluegrass and Allison, they both speak to the unique aspect of oil and gas leases. And the one takeaway from tonight is just remember an oil and gas lease really is a property conveyance. And the Allison court at least has provided some clarification that issue remains clear under Pennsylvania law. It is a conveyance, it is a property interest, and that's how we have to view it through that lens. We're going to pivot now slightly to royalty litigation, which relates to production under oil and gas leases. And we're going to talk about a case from the Southern District of Texas. Again, not binding precedent on Pennsylvania courts, but it does reflect an issue and the interplay between two oil and gas lease clauses that we do have here in Pennsylvania, the royalty clause and the free use clause. And Brendan's going to talk about the Carl versus Hillcorp Energy case and what happened in Texas.
Thanks, Bob. This case was out of the federal district court down in Houston and fairly recent, about Thanksgiving. So again, a new case here to talk about. And this one relates to two interesting clauses that appear that are in the slide. There is a gas royalty clause in this lease that stated that the royalties to be paid by the gas company on gas were based on all the gas produced from the land and sold or used off the premises in the manufacture of gasoline or some other product. And that was supposed to be based on the market value at the well of 1/8 of the gas so sold or used. There is a companion clause, a free use clause. And these clauses typically are associated with allowing the driller to use volumes of gas produced on the property to run equipment on the property. And the free use clause in this particular lease down in Texas stated that the driller will have the use of oil, gas, coal, wood, and water from the property for free, except for water from the lessor's wells, for all operations hereunder. And the royalty on oil, gas, and coal shall be computed after deducting any so used. So those are two interesting clauses that were put together. And ultimately, what the issues were, there were two wells on this property that we're producing, and there is a dispute as to the royalty that was owed by the driller to the landowner. And it took a somewhat familiar route that we see here in Pennsylvania, because in the royalty clause, it said that the royalty was based on the market value at the well of 1/8 of the gas so used or sold. And the trial court in the Southern District of Texas went into a long discussion of what market value at the well meant, how it was interpreted, and it had a significant discussion of what is known as the netback method of royalty calculation, or the workback method of royalty calculation, where you take a downstream price wherever you may sell it, and then you deduct all the costs between that point and the wellhead in an attempt to determine what the market value is at the well. And while it's not necessarily the thrust of this particular presentation, you've seen us speak about it before, you've seen us write about it before. The netback method and the concept of market value at the well being determined by taking a value somewhere else and subtracting cost to that point is based on this concept that costs, post-production costs after gas is produced, necessarily add value. And quite frankly, I just don't believe that is true, that they necessarily add value. It seems a reflexive approach that everyone takes, and respectfully to the court here and other courts that have found it, it seems to avoid an actual inquiry of whether that fundamental proposition is true. But because there is so much litigation concerning the netback method and the what the market value at the well is, the trial court here really focused on that and called that the yardstick, almost how it was supposed to identify what was going on in this particular case. And in doing so, it largely missed the more interesting issue of the interplay between these two clauses here, because the lessee, the gas company, was using the gas produced from this property to fuel machinery and equipment that was off the leasehold. So when the district court looked at the well, the market value language with the at the well consideration, it really focused on that and said, well, we determine the market value at the well by using the workback method as a proxy to get that value if we can't look at comparable sales. And as noted, that's problematic. But it was even more problematic in this particular case because the royalty clause requires the royalty to be paid on all gas or gaseous substances sold or used off the premises or in the manufacture of gasoline. So it identifies a scope, being a royalty is owed for everything sold and used off the premises. But there was a subset of gas that was actually used off the premises that the trial court, really in passing, without a lot of great or in-depth discussion, said, well, no royalty is due on that because the free use provision, which allows the lessee to have free use of oil, gas, and water from the land, that exempts and carves it out. And the court didn't really get into the interplay between the free use clause and what exactly that applied to, particularly the language in there referencing operations hereunder, which we submit would necessarily be related to this particular property, and what was owed under the royalty clause. And what happened was the court used the netback or workback method and its idea of this yardstick, not just to identify a point of royalty calculation, but also to identify what we'll call a point of volumetric calculation. So not only to say, well, this is what the royalty on gas is, the court also took it to say, this is what the royalty on gas is, and here's the volume that it applies to. And regardless of what one may think about the netback method, it's a means of calculating a royalty. It's not a means of identifying what the royalty is actually based on. And so in this particular situation, there was a legitimate issue associated with the geographic scope and the interplay between the free use clause and the gas royalty clause. And how broad is that free use clause? Is it associated with operations everywhere? Or how is it limited? Because operations off the leased premises, well, that's gas used off the leased premises, which falls under the royalty provision. That was really never given a great level of detail. And it's one of these situations where, unfortunately, because of the nature of the complexity with royalty clauses and the litigation, courts can sometimes become attached to a particular idea and expand it beyond what it's supposed to be, regardless of the application in a particular case. So that's a case out of Texas. It's not a Pennsylvania case, but one can see that type of logic perhaps being used in Pennsylvania. One topic of conversation, perhaps for another day, does relate to free use clauses in oil and gas leases and the concept of what a royalty is. And if a royalty is defined as a share of production at the time that oil and gas is produced, one wonders, and I think it's a matter of open question that really has not seemed to have been resolved in Pennsylvania. If a lessee is allowed to use oil and gas that has been produced free of charge, and it's accepted from the royalty obligation, like the Carl Court concluded, does that run into questions with the Guaranteed Minimum Royalty Act and the floor under cases interpreting the Guaranteed Minimum Royalty Act here in Pennsylvania that require a 12.5% royalty on all oil and gas produced, removed and recovered from a property? Because if it's removed and recovered and someone uses it for free, then part of the oil and gas removed and recovered is not going to be subject to that royalty. So that's a Pennsylvania tie. Again, it's beyond what Carl in the Southern District of Texas reviewed, but it is a situation where a lot of people have free use clauses in their leases. And the question is, what is the interplay between that and the royalty clause? How broad is the free use clause about when and where the driller may be able to use free gas or gas for its operations? And how does that impact the minimum royalty obligation? I think that's a matter that needs some study and development here in Pennsylvania.
Yeah, to add to this, Brendan, the Carl case, and it kind of ties into the next case we're going to talk about. Carl, to me, represents another example of where a court is just blinded by a concept, this workback method, and it tries to apply it regardless of the lease language. And we see that here in Pennsylvania, and we're going to talk about that momentarily about Kilmer, where courts just, this idea that the workback method just applies to every lease and applies to every royalty calculation. The fundamental problem with Carl is, like you said, Brendan, there was gas that was being used off the premises. Now, the landowner and Carl acknowledge, hey, look, if you're going to use gas to fuel operations on my leasehold, you know what, you can use it. But if you're using it off the leasehold, the free use clause doesn't apply, and you owe me a royalty on that volume of gas. And the court said, no, on that same volume of gas, we're going to allow the driller to just treat it as a deduction. And that's what Brendan was referring to, that the court just got wrapped up in this workback method that it couldn't find its way out of the bag, and just said, you know what, the driller can deduct that volume of gas as a deduction. And that's not what the lease language provided. But let's talk about another case that's a Pennsylvania case that I think reflects the same the danger of a court being blinded by a concept and losing sight as to what the lease language actually says. And we're going to talk about Dressler family versus Penn Energy. And this was a case that was decided by the Court of Common Pleas in Butler last spring. But the reason why Brendan and I decided to include it in this presentation is because the matter is currently on appeal before the Pennsylvania Superior Court. And it's going to be, it's our understanding it's going to be argued shortly. We're not involved in the case, but we've been following it. And it reflects this view that Kilmer applies to everything and everyone. And that's just simply not the case. Kilmer was a much more restricted holding, but the drillers have, over the last 10 years, tried to apply it in every possible scenario, and have even tried to adopt this Kilmer rule that allows deductions in every oil and gas lease, regardless of the language. Let's take a look at the Dressler lease. It was a 2007 lease.
But maybe before we get into the lease, if you just wanted to provide a Reader's Digest summary of what Kilmer actually was about.
Yeah, I mean, Kilmer was a case that originated under the Guaranteed Minimum Royalty Act, the GMRA, and the Kilmer lease actually provided for and authorized the driller to take deductions. The landowner in Kilmer said, hey, wait a minute. If my royalty rate in this lease is 12.5%, that's the minimum royalty under the GMRA. The landowner said, if you take deductions, you're going to drop my net royalty below the state minimum of 12.5%. And the court in Kilmer said, no, the lease allows for deductions, and the fact that the deductions are going to take the net royalty below 12.5% is not going to invalidate the lease under the GMRA. So that's Kilmer. And Kilmer's been since, at least by the drillers, they've attempted to expand it to apply to every oil and gas lease in Pennsylvania, that it's a blank check to take deductions. Brendan, can you go back to the prior slide? Slide 11. The royalty clause in Dressler was somewhat unique. It said that the landowner was entitled to a royalty of 1/8 of the gross proceeds received from the sale of the same at the prevailing price for gas sold at the well. So that language alone doesn't expressly authorize deductions. It doesn't fall into the Kilmer methodology per se. And it doesn't even say we're going to value the gas at the well. It just says you get a royalty of 1/8 of the gross proceeds received from the sale at the prevailing price for gas sold at the well. But in Dressler, no gas was being sold at the well. And I think that's a critical point that the court just didn't appreciate. The trial court held that this clause was unambiguous, which I'm going to point out is a rather peculiar finding, and that the phrase prevailing price at the well required the driller to first arrive at a wellhead value. And that, in my opinion, doesn't make sense and is flawed when you look at that the gas was not being sold at the well. Since gas was not being sold at the well, we should have simply looked at the point of sale. And that's where the gross proceeds should relate to. Next slide. To appreciate the concern we have with Dressler, I want to just briefly review what the basic elements of every royalty clause, because that gets lost in the discussion often. Every royalty clause has really three components: the fraction, which is 12.5, 15, or 18%, the yardstick. And this is the part of the clause that identifies what we're going to apply the fraction to. And there's really three elements. Market value, you're going to apply 15% of the value, or 15% of the proceeds received, or 15% of the price paid. So it's really market value or proceeds or price. That is the yardstick. That's how we're going to measure the fraction. And the third element is where we often find a lot of litigation, and that is, where are we going to measure the yardstick? And there's two locations: the wellhead or the point of sale. And typically, when the yardstick is proceeds or price, the yardstick location is at the point of sale. In other words, 15% of the proceeds received. If your royalty clause says that, a plausible legal argument can be made that the location where we measure that yardstick is at the point of sale, and there's no deductions. Conversely, if your lease says 15% of the market value at the wellhead, then the yardstick, the market value, is to be measured at the wellhead, and that invites Kilmer. That is the one situation where Kilmer does apply, because we're measuring the yardstick at the wellhead, but we're selling gas downstream. So we have to net back all those costs between those two locations to arrive at the market value. Next slide. The Dressler lease utilized the second yardstick. It clearly said 1/8 of the gross proceeds received from the sale. But it also contained that at the well language. I submit that creates an inherent ambiguity, because now you're mixing and matching the two concepts that we were just talking about. You typically don't measure the second yardstick, the proceeds price, at the wellhead. That's what you measure that typically at the point of sale. So it creates an ambiguity. And I'm not just making this up. There's a Texas Supreme Court case that said there is an inherent conflict between gross proceeds and at the wellhead and arriving at the value of gas. You can't have both those in a royalty clause. Creates ambiguity. So I would submit that in Dressler, the trial court should have said, this is ambiguous. We need to ascertain the intent of the parties of what they really meant here by this royalty clause. Alternatively, I think there's an argument to be made that the trial court became fixated on the phrase at the well and ignored or neglected to put any weight on the phrase for the gas sold. In other words, if there was gas sold at the well, then you get the gross proceeds of the price for that gas that was sold at the wellhead. But if the gas is not sold at the wellhead, then it should be the gross proceeds received from the sale, regardless. So Dressler, again, I think it's a confusing opinion. We're not involved in the appeal, but we'll have to see how the Superior Court comes down. And if it continues to just rubber stamp a broad application of Kilmer, regardless of the actual language in the royalty clause, and regardless if the language that was utilized, unfortunately, creates some ambiguity. And if a written document contains an ambiguity, the court is instructed to take parole evidence, testimony from the parties as to what the parties meant when they signed this lease back in 2007. Did they anticipate that post-production costs could be and should be deducted, or was the intent to have a gross royalty, a cost-free royalty? I think the record would have to invite that kind of testimony to unravel the ambiguity of this Dressler clause. Next slide. Next case we're going to talk about is also a Texas case. It's Engler Energy versus Bluestone. That's a mouthful to say on St. Patrick's Eve. Engler was a case that is problematic for Pennsylvania landowners only because we're seeing this same argument creep into the driller's arsenal when they try to justify post-production costs. At issue in Engler was a 1986 deed that reserved a non-participating royalty interest, an NPRI. And that instrument said that, we're going to carve out an NPRI of 1/8 to be free of cost in the pipeline, if any, otherwise free of cost at the mouth of the well. Sometime later, 30 wells were drilled on this 648-acre parcel, and those 34 wells were connected to a comprehensive gathering system. That gathering system was owned and operated by a third party. It was not owned and operated by the lessee. Between 2004 and 2016, the lessee paid out royalties, but did not deduct any costs related to the gathering system. In other words, the lessee was billed by the third party certain costs to move the gas through that system. The lessee, however, did not pass those costs on to the landowner. It did not deduct those from the royalty. Ostensibly, it's because it viewed the 1986 as providing as free of cost into the pipeline. And the gas was actually being sold, not on the gathering system, but way downstream on the transportation pipeline. So for all those years, no deductions were taken. In 2016, Bluestone became the operator of the 34 wells. Unlike the earlier lessee, it valued the 1/8 royalty at the point where the raw gas went into the gathering system, as opposed to the interconnect with the interstate pipeline network. That had a dramatic effect on the royalties because overnight, significant deductions for gathering, processing, and transportation were now deducted from the landowner's royalty. The landowner brought suit, and essentially it made three arguments that I found compelling. Number one, it said, the gathering system is not a pipeline. It's a series of pipelines. It's a network of pipelines that move gas from wells to a processing facility. So to equate a gathering system with in the pipeline is simply wrong. Second, it said, look, in the pipeline must mean something different from mouth at the well, because mouth of the well is very close to the wellhead. And so the in the pipeline has to be referring to a downstream location that is different from the interconnect with the gathering system. And also, the landowner put great emphasis on the word otherwise, because if there was a pipeline, a sales pipeline that could be identified, that's where you value the royalty. Otherwise, it was to be valued at the mouth of the well. But because the mouth of the well is the same as we're very close to the wellhead, it has to be a different location. Finally, the landowner argued that when this deed was drafted back in the 1980s, the phrase in the pipeline typically meant the pipeline where the gas was sold. It didn't mean the gathering system. It didn't mean the first connection with the gathering system. It meant and referred to the sales pipeline, which in this case, the gas was being sold downstream on the interstate network. The trial court agreed with the landowner and awarded damages in the amount of $88,849. And that represented the deduction of the cost between the wellhead and the interstate pipeline network. Once the gas got to the interstate pipeline network, the deductions would be permissible. The Court of Appeals reversed, and it came up with a position where at the wellhead and in the pipeline mean the same thing. And as Brendan talked about earlier, when a lease has a royalty valuation point at the wellhead, it invites a Kilmer-like analysis and invites use of the Netback Method. So in the Bluestone case, the Court of Appeals said, well, in the pipeline it means the same thing as at the wellhead. So the royalty is to be valued at that location. That was a pretty big leap. And the Court of Appeals, it further assumed that the pipeline that was referenced in that 1986 deed was the entire gathering system, as opposed to a particular location where the gas is being sold. Next slide. On appeal to the Texas Supreme Court, the Texas Supreme Court affirmed, but fortunately, it didn't adopt a universal rule that says when we have in the pipeline language in a royalty clause, that automatically is going to mean the same thing as at the wellhead. It rejected that strict reading, and it declined to create a universal rule. Nonetheless, it didn't reverse, and it affirmed the result and effect of the Court of Appeals, which means that the trial court opinion was reversed, and that no deductions or the deductions were held to be authorized and permissible. We are starting to see this same argument creep into Pennsylvania law. We're starting to see drillers make the same argument that if a royalty clause contains the phrase free of cost into the pipeline, that the court should just use that phrase in the pipeline. Well, it just means at the wellhead, that they're one and the same, that they're, you can plug and play the two clauses, they mean the same thing, even though there's no textual support for such an interplay. So if you have a lease that has that language, that the royalty is to be calculated free of cost in the pipeline, be on the lookout that drillers may start to use that language to justify the deduction of post-production costs. Even if they haven't done so in the past, they may now say, well, we've reread it and we believe that costs can be deducted because in the pipeline, based on the Bluestone case, means the gathering system. So once the gas goes into the gathering system, all costs that are incurred downstream from that location, gathering, compression, processing, dehydration, transportation, all those costs can now be deducted. So we believe it's a flawed opinion, and we hope that Pennsylvania courts do not adopt the logic or rationale of the Court of Appeals or the Texas Supreme Court. We don't believe that Pennsylvania should go and follow that approach. But we'll have to wait and see. But we are starting to see the in the pipeline argument here in Pennsylvania. So be on the lookout for that position.
And Bob, on that front, the one thing that I found to be unsatisfying in both the Court of Appeals and the Texas Supreme Court's decision in this case was largely the write-off of the language free of cost. And, oftentimes landowners, royalty owners in litigation face gas companies who say, look, the language says what it says, and it says what we mean. And courts very frequently say yes. And that was also an issue in Dressler, where the prevailing price for gas sold at the well doesn't seem to have actually been recognized by the court there, and saying, well, doesn't it say prevailing price for gas sold at the well? Are you selling at the well? Why not? Doesn't the contract say that? So it seems that courts, part of the theory here is there's an idea and they leap to the idea without really taking a step back to see what applies. And, as Bob, you noted earlier, you could have a proceeds or price paid lease, which in our view calculates it at a downstream point of sale, or you could have a wellhead calculation. But there are many, many different types of words that people use in royalty clauses. And one type of language that was used was cost free. And the idea was, well, isn't that a gross royalty? And gross royalty may or may not actually mean gross royalty. Free of cost or cost free might not actually mean that. And it was unsatisfying here, because if the concept under Texas law, which was recognized by the courts, was that in Texas, an oil and gas royalty doesn't bear any of the production costs, then the law already says it's free of cost out of the ground. So you have to give effect to what did they mean by free of cost. And in a lot of these decisions, and I think this is an exemplar of it, critical points of the clause are just glossed over without examining, why does that language actually exist? What does it do here? And that seems to be an issue where you just kind of focus on a pole star and go to that, versus saying, what does this mean as a whole? What were they trying to get when they drafted this language?
You and I talk about this all the time, Brendan, that it seems that courts, and I don't know why, in particular with oil and gas litigation, they seem to have a predetermined conclusion, an endpoint, and they work backwards from that premise. And I think in Dressler and Bluestone, those both reflect the court had to reach the conclusion that, you know what, deductions are going to be allowed here. The netback method has to apply. It must apply because that's what everybody tells us. So if the netback applies, we have to figure out how to square that into this royalty clause, as opposed to, let's look at the royalty clause and see what it really means. Is it ambiguous? Do we need parole evidence? Or if it's not ambiguous, let's apply it as written and go from there. Here it says free of cost in the pipeline. A gathering system is not a pipeline, and the parties should obviously intended that the royalty was going to be cost free. Otherwise, why would they have used that language? But we're running out of time. If you could hit JJK Mineral briefly to give the audience a flavor of that case, and then we'll wrap it up.
Sure. I don't want to keep anyone from dinner or going outside. If you are where Bob is, and it's one of the 6 days of the year, it's sunny here in Pittsburgh. This case briefly kind of brings everything back full circle. And this is more of a procedural type matter than.
You got like 2 minutes, Brendan.
Yep. And then a strict oil and gas case. So this was an 1897 deed that was executed after the property owner signed an oil and gas lease on the property. And in this 1897 deed, the property owner, Meek, conveyed to this gentleman, George Swingle, all of his oil and gas right, being the full 1/2 of his 1/8 interest, 1/16 royalty, to have and to hold forever. And the question in this particular case was whether this language was a conveyance of all of Meek's oil and gas, or whether it was just a conveyance of his rights under this South Penn lease that he had executed. The case was here in the Western District of Pennsylvania, and EQT was involved, as well as a mineral buyer who acquired the rights from Swingle and argued that no, Swingle had acquired the oil and gas in 1897. EQT, on the other hand, said no, all that Swingle got was a royalty interest under that old South Penn lease. There was an argument about an interesting issue that is a topic in and of itself of the estate misconception theory. And you will see that in old deeds where people will seemingly reference their oil and gas ownership in the context of their right to receive a royalty. And the trial court was asked to dismiss potentially the case of, did JJK actually acquire an oil and gas interest or not? And the trial court said no. All that JJK acquired was a royalty interest under that South Penn lease, because that is how Meek, the seller, defined the interest that was being sold. And the court dismissed the case without allowing really any development of the record to see, was that really true? And it's a bit concerning because the language is not entirely clear. It's 100-some years old, so there's not going to be any witnesses around, but it was a deed, and a deed conveys a real property interest. A royalty interest under a lease is not a real property interest. And the court never really addressed why that was the case. And the court never really addressed other considerations of, well, was it just a royalty interest under this lease or a royalty interest in any lease? And so the case was dismissed, but it's one of those situations where, again, it's a matter of taking a look at all the language, and oftentimes the language is not entirely clear. So in those types of situations, it seems better to allow the record to expand and to see what can we get to determine what the parties really intended. And that's a similar situation with the royalty clauses. It's a similar situation with deeds here in Pennsylvania, because these things go back a century. So it's important to take a look at all the language and to really sit back and consider, what does it mean? Why are these phrases here? What were the parties intending, or what did they view them by back then? And then try to give effect to it based on that framework versus just simply saying, this is what I think that it means, whether it's a royalty clause or something else because of one concept, and then going from there.
Well, I think we're out of time. I wish we could speak, go on a little bit further, but we only have 1 hour. Any questions, comments, concerns, feel free to reach out to us. Have a great evening and happy St. Patrick's Day.